So welcome to A6, A History and Future of Legal and Peer Advocacy in the Forensic System in Ontario. My name is Erin Paquette. I'm the Policy Analyst Justice Lead at CMHA Ontario, and I will be one of your facilitators, moderators for the session. My colleague Taryn from our Center for Innovations in Campus Mental Health is also here as a moderator, and we will be helping throughout the session. So just a couple of housekeeping notes before we jump in and turn it over to our speakers. So I see that everyone has their microphone muted. So thank you so much for that. It helps keep some of the sort of noise and distractions to a minimum. Once we reach the Q&A portion of the discussion, please, by all means, feel free to put your camera on if you feel comfortable. It's great to see faces during conversations, particularly in these smaller group discussions. A brief reminder, of course, to always just be respectful during these discussions. And if you want to speak, you can raise your hand or use the raise hand feature in Zoom. And then either myself or Taryn will let you know when it's your turn to speak. Please enjoy the opportunity to connect with each other. Feel free to share your thoughts in the chat on the topic of the session. All of our sessions, again, just a reminder, are being recorded, and these are going to be posted for 6 months, as well as PowerPoint presentations that we have with consent. Those will all be posted on the HSJCC website, and I will post the link to our website in the chat throughout the discussion so that you can keep that on hand for reference. On the conference platform, if you could please fill out your profile. And there's also an option to receive a certificate of attendance for this conference. So when you go into your profile, there is an option to do so, and you just have to click yes to get that certificate. And then, of course, a reminder, following the discussion this morning, if there are any incidents of inappropriate behavior, please, by all means, do report those to the session, to the planning committee for the conference. So just a quick reminder for everyone to make sure that their microphones are muted, with the exception of our speakers, of course. And I will turn it over to Jennifer Chambers, and Taryn and I will hop off camera, but we will still be here, of course. Go ahead, Jennifer. Thanks.
Thank you. I'll also acknowledge Hannah Wilson, who's behind the scenes, enabling Anita Szigeti and I on technical matters, because we both suck at. Thank you, Hannah. So the opening graphic I chose to represent the ladder that people are supposed to progress along within the forensic system. It's sometimes jaggedy, but supposed to be generally upward momentum towards rejoining the community. Next slide. Thanks. So the NCRQs is supposed to be treated with the utmost dignity and afforded the utmost liberty compatible with his or her situation. The NCRQs is not supposed to be punished. This is what was read in WinCo, the foundational case for forensic law in Canada. It was also the first case on which there was a legal intervention by a survivor advocacy group. This is actually the brainchild originally of Dan Brodsky and Randy Pritchard, who had the thought that perhaps when talking about law that affects forensic clients, survivors throughout the nation, there should actually be a voice of the people who are most affected. So we had to do a sort of guerrilla advocacy. This had never happened before. We ended up having someone from the community who just recently graduated from law school represent us before the court to ask for intervener status. Intervener status means that a group that represents the community can make submissions in the court on law that's going to affect that community. That's one thing that it can mean. The legal aid wasn't used to groups like ours applying, and we didn't have a lawyer who was experienced with drafting an application, so legal aid staff did it for us. I was giving instructions to a phone booth outside the hospital. It was all very grassroots enabled, but we did get, for the first time, intervener status for a consumer survivor group at the time, and that was for a case that was called LePage. And LePage was about capping. Capping means that because when people are in the forensic system, their sentence, you might call it, is indefinite compared to people who are in the criminal justice system who get limits to their sentence. We are saying it's an unjust system because the means of getting out of it are very unclear, and the length of time in detention was typically much longer than if people had actually been convicted and within the criminal justice system. So that was why we were taking the case up. And at the first level of court, it was, we won the case and they said that there should be capping, but they held the law over because they knew there'd be an appeal. So then we went to the Ontario level of court. At the time, I was working for the Queen Street Patient Council at the time, which is forerunner to the Empowerment Council. And at Ontario level, they decided that no, this should not happen. So then we appealed up to the Supreme Court of Canada. And were granted intervener status at every level. We were represented at for the very first initial application by Marian Friesen, and then Paul Burstein represented us at the different levels of court, all the way up to the Supreme Court of Canada. So at the Supreme Court, LePage became joined with Winco, and that's what the case is called if anybody wants to look it up. So I'm going to tell you some of the most important things to take from the Winco ruling. One is that the accused has no burden to prove that they're not dangerous. And the other is that if the evidence doesn't support the idea that the NCR is a significant risk, they don't have to do anything. They have to be absolutely discharged. And further, that dangerousness has a very narrow specific meaning. Has to be supported by evidence, has to be real risk of physical or psychological harm. This potential harm must be serious, and this harm must be criminal in nature. It also stated that the Court of Review Board has a duty to seek out evidence favoring release, not just favoring restriction, that the review board has to make the disposition that's least restrictive and least onerous, that the accused's personal needs need to be considered, that the NCR accused are entitled to sensitive care, rehabilitation, meaningful attempts to rejoin the community, and there has to be a resistance of the documented tendency to overestimate dangerousness. So at first, when we got the ruling from Winco, we thought we had lost because they didn't support capping. But then when we read the ruling, we discovered that they said that the NCR, or it's then called the NCR, stands for not criminally responsible by reason of a mental disorder. Should have said that earlier. At the time, I believe, was still when the system was referred to as for people found not guilty by reason of insanity. So the Supreme Court ruled that that system could only operate if it operated in the ways that were outlined in Winco. It was a fair ruling. It outlined how the system should operate, but it also maintained the option that if somebody committed an act that was considered criminal but who lacked criminal intent, that there should be a different outcome for them than for people who had a criminal intent. Which particularly makes sense. And the ruling restricting dangerousness in Winco was a very sensible ruling because there's considerable social science evidence to indicate that there's no way to really predict dangerousness, so dangerousness has to be narrowly considered. The reality is that people can be grouped in a way that prediction can seem quite high when trying to predict dangerousness, but that's only when they're seen as a group. If they're trying to do predictions on an individual level, it's actually very difficult to predict dangerousness. And the difficulty is that there's not really a good system of predicting dangerousness. So the system can therefore resort to a lot of arbitrary measures for deciding whether or not to release people. And so my notes actually got out of order because my water bottle spilled on them. So I'm moving back and forth a little between slides. So years ago, the Mental Health Legal Advocacy Coalition, which is the organization that existed between the Queen Street Patient Council and the Empowerment Council, conducted the first ever survey of people in the forensic system. And all of the points that were made were indicative of the ongoing issues that Winco identified. And they became the basis for cases that then had to make their way up to the Supreme Court of Canada one by one, which Anita is going to talk about now.
Hi. So I think we did skip over a little bit of something. But I think slide 4, I was going to have some comments on, but I take it we're now on to speaking about the 3 cases, Darson, Tulakorpi, Pinot, and Mezzi. Is that right, Jennifer?
Yes, feel free to make your remarks anyway, even if that particular slide is not up.
Okay. The earlier slide that I was going to speak to, I think, was asking for my experience in representing people before the Ontario Review Board, and to give some examples of reasons why, despite WINCO, and despite the clear direction that Jennifer has so clearly set out, that people cannot be kept in the criminal justice system under review board jurisdiction once they are no longer posing a significant risk. So I was asked to address some examples of reasons that the review board will sometimes rely upon to keep people in the system for longer, and things that prolong detention orders, for example, as a result as well. So there are about 5 things that we hear commonly at these hearings. The first is that the individual with the mental health issue either has no insight or has limited insight, in the words of psychiatry, into their mental health condition and or their need for treatment and or the circumstances and risk factors that led them to commit the so-called index offense. Second, what blocks absolute discharges often is a lack of non-forensic psychiatric follow-up supports or outpatient teams. Third, we might hear that there are concerns that an absolute discharge or a conditional discharge or just being discharged from hospital would place an unusual or an extraordinary stressor on the individual. And there's concerns about the person destabilizing as a result and requiring closer monitoring or follow-up by a forensic team. There's sometimes, fourth, a lack of pro-social supports identified. So if you don't have a lot of friends or family or a job, they might say they're worried about how you're going to spend your time and you don't have sufficient supports or structure in the community. And finally, probably the biggest stumbling block, as I expect everyone will already appreciate, to discharge, whether an absolute discharge or discharge from hospital, is a lack of housing, either or both of affordable, subsidized, or supported or supervised housing. So that's what I was going to talk about earlier. And now, Jennifer, if you want me to move on to talk about these cases.
Yes,
and
please do.
I think we're talking about Starson and Tulakorpi, Pinot, and Mezzi. So I'll give you a little background and then tell you how it's worked out on the ground. So Starson is the leading case on capacity to consent to treatment, including psychiatric medications. This case was decided in 2003, and the Empowerment Council, together with Mental Health Legal Advocacy Coalition at the time, argued that the threshold for capacity to make your own treatment decisions should be a very low threshold to allow for as many people as possible to retain the right to refuse powerful mind-altering psychiatric medications, particularly antipsychotics, which we know can have very harmful and significant, often permanent and irreversible side effects. So the Supreme Court of Canada agreed with Professor Starson that he should be able to make his own decisions as long as he could understand the information given to him about these medications and appreciate the consequences of accepting or refusing treatment. Whether he then chose to consent or refuse to the psychiatric medications was up to him as a capable person. So this case has changed the landscape for people who are at risk of losing their autonomy and being found incapable, with substitute decision makers consenting to these medications for them. The sort of general upshot has been that many more people have been found capable since 2003 than before then. However, over time, the application of the test, which is Section 4 of the Healthcare Consent Act, the test for capacity to consent to treatment, the application of it has sort of started to slip back into pre-Starson days at some points. Starson really just called for the person to be able to acknowledge that there's a possibility that they had a mental health condition that affected their mood or behavior. They didn't have to agree that they had a mental illness per se, or that having that condition was a negative thing in their life. That was the point of the case. These days, we're seeing, if not necessarily a requirement that you agree with the particular diagnosis that you've been given, whether it's the label of schizophrenia or bipolar, we are seeing some panels of the Consent and Capacity Board more insistent that you agree that you have a mental illness per se and that you need treatment. And only when you do that are you then free to reject it, as opposed to just recognizing the possibility, but perhaps still disagreeing. So that's one very important case. Tula Corpi and Pinnett were decided in 2003, 2004. These two cases built further on Winco, but in relation to the conditions of a discharge disposition of the Ontario Review Board. Once the review board finds that a person does pose a significant threat to the safety of the public, they have to make the disposition that is the least onerous and least restrictive of the person's liberty. And the Court of Appeal interpreted that to mean that the board had to pick the least restrictive option just between a conditional discharge versus a hospital detention order, as long as the disposition choice did not compromise public safety. So we argued in the Supreme Court of Canada that it was not just the discharge versus detention decision that had to impair the person's liberty as little as possible, but that the same criteria had to be applied to all the conditions of discharge or detention as a package, including what level of security the person was detained on and what terms or restrictions were put into their discharge order. So the Supreme Court of Canada agreed with us, and these cases have had profound implications now for our clients at various hospitals, including at CAMH, to try to ask the review boards to detain NCR accused not just on a forensic service, for example, at the hospital, which is something we're seeing now. Forensic institutions are trending toward de-designating their units and taking away security level distinctions. But we've been able to push back on the strength of this jurisprudence, particularly to the Corpi and Pinnett, to insist on specifying the lowest level of security of detention that the person needs, because medium versus minimum historically, for example, at these hospitals, the medium secure forensic units have been much more restrictive. However, we're also seeing some blurring of the lines and sort of a bit of a slipping back into earlier muddying of the waters now, where a lot of conditional discharges are really becoming effectively detention orders, as people are being asked to consent to a term in their conditional discharge that they would agree to come into hospital and to admit themselves to hospital if the treatment team asked them to. And that's, of course, the custodial authority that hospitals otherwise have on detention orders. So there's a bit of a backslide there. And then finally, Mezi, I think, is the last one that I'm talking about here. And Mezi, this case concerned an Indigenous man under the BC Review Board who was discharged without appropriate supports many times from hospital, only to be brought back in because he had engaged in substance use every time. The British Columbia Court of Appeal agreed that a treatment impasse existed because the hospital had not provided culturally appropriate services and supports to Mr. Mezi, and the board was right to order the hospital to conduct a new and independent risk assessment, come up with a new treatment plan, and enroll Mr. Mezi in Indigenous services. The government appealed on the ground that these review boards had no jurisdiction to order anyone but the NCR accused person to do anything, and they had no jurisdiction to bind the hospital. The Supreme Court of Canada disagreed with the hospitals, and this case became very important for long-term NCR accused who are not making progress in the system. We have since argued many times that our clients were in a treatment impasse at a particular hospital, and got them ordered, either transferred to another hospital or obtained an order for an independent assessment of their risk and treatment needs, or got the court or the review board to order the hospital to find them appropriate housing or services. And this case has really helped the lives of many NCR accused tremendously over the years. One caveat is for about a 10-year period, sometimes these treatment impasses did not have the intended or desired result of an independent assessment or a move, because hospitals were successful in blaming the accused person for the impasse by simply pointing out that it was the accused person who was refusing medications, for example. And that remained the case until a case called Gonzalez, maybe about 5 or 7 years ago, where the Court of Appeal sort of reversed itself and reinterpreted things to say it's never about laying blame at the feet of the accused, even if they're not cooperating in a treatment plan. It doesn't matter what's causing the impasse. If they are not progressing and not likely to progress, then the review board has an obligation to intervene and break that impasse. So that's everything on these cases. Uh-oh, do I keep talking?
Yep.
Oh, just keep going. Okay. So
Actually, before you move on I'll just say one thing about Starson, which was something I really loved about Starson, was that he was a very smart man, and he described his situation as one in which, if he denied that he was mentally ill and needed psychiatric medication, then he was therefore mentally ill and needed psychiatric medication. Whereas if he agreed that he was mentally ill and needed psychiatric medication, it would make no sense for him to not take psychiatric medication. So he said the system's set up as a catch-22, in which there's no choice I can make, in which I actually get to consent or refuse the treatment that's proposed.
Yeah, he's really funny and a really smart guy. And I think the way he was able to express his dilemma in that catch-22 really helped this case, to be won all the way up to the Supreme Court of Canada, because he had such a sort of sophisticated use of the English language that he could really put these things in a way that it was inescapable, the conclusion that there was something wrong with the way the law was being interpreted. Okay, so we move on to one of my personal favorites, G, the case of G in Ontario. And in G in Ontario, the EC was granted intervener status at the Court of Appeal and then at the Supreme Court of Canada. This case dealt with the constitutionality of Ontario's sex offender registry as it applies to NCR accused. We were successful at both levels of court. In Ontario, the sex offender legislation known as Christopher's Law automatically placed all NCR accused whose index offenses on which they were found NCR were of a sexual nature on the sex offender registry. The problem was that there was no way to get off it once you were mandatorily put on it, and the severity of the offense was only relevant to how long you were mandatorily on the list. But in most serious cases, it was for life. So there was nothing the NCR accused could do to apply for an exemption or a termination of the order, even after they were absolutely discharged by a review board, an expert tribunal that had declared that they no longer posed a significant risk to the public safety. Other criminal offenders who were not found NCR had other options, a number of different ways that they could either escape being placed on the registry in the first place, or where they could be removed in the event of a record suspension or a pardon, for example. So both the Court of Appeal and the Supreme Court found that the fact that NCR accused had no off-ramp options from their inclusion on the sex offender registry was a violation of their Section 15 right to equal treatment under the law. The sections that included them in the registry were declared unconstitutional, and the government was given, I think, a year's suspension to devise a new system allowing NCR accused, once they received an absolute discharge from the review board, to apply for a termination of their status on the Ontario Sex Offender Registry. So this case really has the potential to improve the lives of many NCR accused who are currently or were at the time on the Sex Offender Registry, which meant very onerous reporting obligations and invasive scrutiny and supervision of them, in addition to what the Ontario Review Board already did. In this case, the Supreme Court of Canada cited and specifically relied on the Empowerment Council's factum and submissions where we argued that NCRQs who are included on the sex offender registries are exposed to the double stigma of being found NCR as well as labeled sex offenders.
Let me note that being called a sex offender is a very low bar.
Yes.
You could do things like hug somebody who didn't expect it.
Absolutely. I have one client that we're still working our way through appeals, and this was attempts to kiss women all in a matter of 25 minutes on the TTC during sort of one episode, and on the sex offender registry, sexual offense. So shall I move on to Sullivan and Chan?
Please.
Okay, so this is Sullivan, Chan, and Brown were all related cases. All the cases involved people who took substances, mushrooms in 2 of the cases, and an overdose of Wellbutrin in the 3rd. And each person became intoxicated to an extreme degree, such that they lost all voluntary control of their actions, something in law that is known as a state of automatism. This state is a defense to most criminal acts, but Section 33.1 of the Criminal Code previously exempted offenses of violence from this defense altogether. So in other words, if you became an automaton as a result of self-induced extreme intoxication and you committed a violent crime, you could not rely on the defense of automatism. Now, in Mr. Chan's case, Mr. Chan brought a cross appeal in the Supreme Court of Canada, saying that if he could not avail himself of the automatism defense, then he should have been found NCR. And the NCR defense should be expanded to include people who become automatons as a result of self-induced extreme intoxication alone. So the Empowerment Council intervened in part to oppose this proposed expansion of NCR, saying that the system is not designed for these cases, could further stigmatize NCR accused more than they already were. So in all 3 cases, EC took the position that nobody who is not responsible for the crimes they ultimately commit, because they are not morally culpable and did not appreciate what they were doing, should be convicted of those crimes as charged, the ones that they ultimately committed, where there was no way to foresee those outcomes. So they should either be acquitted or a new offense of extreme intoxication or extreme intoxicated criminality should be created, where the person is only held responsible for the crimes that they could reasonably foresee would result, where extreme intoxication could be reasonably foreseen based on the particular drug they took, the particular amount of that drug, and the circumstances of their consumption of that drug. So this position was ultimately accepted, and the law was changed so that the only time you cannot rely on automatism as a defense due to self-induced intoxication is if your drug use is a marked departure from ordinary use or ordinary conduct, and the violence that results was reasonably foreseeable. EC's main contribution in all these cases, for which EC received much praise from both counsel to the accused persons, but also from the AG's opposite, was to fight against the positions taken by the AG Ontario in Sullivan and Chan, and by Alberta's AG in Brown, that any use of any drug, whether illicit substances or medically prescribed drugs other than as prescribed, is so unreasonable, such a marked departure from ordinary conduct by Canadians, that it could be the basis of establishing a guilty mind in relation to otherwise unforeseeable tragic consequences that result from violent conduct when the person is in this automaton-like state. So these were very difficult cases, but the important contribution that the Empowerment Council brought to these cases was to caution the court in the strongest terms not to work with stereotypical misconceptions about drug use and not to make automatic links between drug use and dangerousness or psychosis and dangerousness, that these connections cannot be and should not be presumed. We were there to remind the court that millions of Canadians use drugs responsibly and without causing any harm to others every day, and that whether or not a substance is legal or illegal is not any indicator of whether it is a drug that will make someone violent.
One case, there's also it was an issue of prescribed medication that someone took as an overdose in an attempt to commit suicide. So we also argued that they should not be responsible for the outcome of that.
That was Sullivan, and he'd been prescribed Wellbutrin, which is a well-known antidepressant that's frequently prescribed as a smoking cessation aid. And I believe that's why he was taking it. He was originally prescribed it to try and help him stop smoking cigarettes. He then took all of the Wellbutrin he was prescribed in an effort to take his own life. That was his goal. But he became psychotic and attempted to kill his mother instead. But he never had any intent of hurting her. So that law has been changed and now is in line with what we suggested could be lawfully crafted into the legislation. So I think, are we moving on to the next slide? Okay. I'm gonna, do you want to say something about this, Jennifer? Or should I just launch into Kasai?
Oh, go ahead.
Okay, so I'm going to let people have a look at this slide. This was a really interesting case of a double homicide that came out of, I think, Alberta, where a lot of really interesting cases come out of. And it concerned Mr. Kasai had been found fit to stand trial on this double homicide, but he refused to retain or instruct counsel. He wanted to represent himself, but he then wouldn't participate at all or put forth any defense in his trial. And the question really became, what power or discretion does have a criminal trial judge have to appoint a friend of the court, an amicus curiae, to assist the court when you have a self-represented person who clearly has some serious mental health issues that prevent them participating in the matter and putting forth a defense, but yet someone who is still found fit to stand trial. So they have the right to conduct their own defense, and their autonomy to be self-represented should be protected. So this case, which was just heard recently, I think in the last year, was an opportunity for the Supreme Court of Canada to revisit a judgment it rendered about 10 years before in 2013. That judgment was called CLA and AG, Criminal Lawyers Association versus Attorney General of Ontario. Long story short, that case, CLA and AG, effectively ended the use of amicus curiae to level the playing field in sort of similar situations. And courts and tribunals sort of had to pretend to appoint the friend of the court into a more neutral role, or for the amicus to not be appointed at all. And that judgment, CL and AG, which was really a fee dispute, the government didn't want to pay higher than legal aid rates to court-appointed amicus curiae. That fee dispute and the judgment from the court after that really altered the lay of the land, and to the great detriment of people with lived experience of mental health issues. They didn't have access to effective amicus curiae who would really advocate their perspective, their position, or in their interest in the last 10 years, not in the same way as they did prior to CLA and AG. So Kasai was an opportunity to revisit that judgment. And although the court upholds itself and says it's just going to flush that out and give some clarification, at the end of the day, this case really backpedaled from CLA and AG and reversed a lot of the damage of at least how it was being perceived by trial judges. So this case, once again, reaffirms that a trial judge, presiding over a serious criminal matter where you have a self-represented accused person who clearly has mental health issues, even if they've been found fit, yes, they can run their own defense, but the trial judge has a very broad discretion to appoint a friend of the court or amicus curiae to level the playing field. And that amicus curiae can take on a very adversarial role to advance defenses on behalf of the accused, as long as they don't conflict with the theory of the accused that they themselves may be advancing. They can take on an adversarial role. They can really test the evidence of the Crown, put the Crown to the strict proof of their case. They can advance certain other alternative theories, alternative defenses, make submissions to the court, cross-examine witnesses, and really afford the trial process that balance that's more likely to guarantee a fair trial process, which is ultimately the goal, and also a reliable verdict that has been arrived at through a properly adversarial trial, because that's what our system rests on. So that's all I have here, and I think that's the end of my contribution on the case.
Nope, I think you have one more.
Oh, do I? Oh,
I think so. Oh, no, I was wrong. Sorry, you were correct.
thank God, because I have nothing else to say. Okay, good luck, Jen.
So I'll be looking so more at the effects of some of the rulings. So post-Winco, there have been some studies, and one of them found that after the Winco ruling, that the number of absolute discharges in the forensic system in Ontario increased. The length of stay seemed to change little. However, they used an average, which is a bit of a difficult statistical application for that purpose, because it could be influenced by somebody who has an extremely long sentence, for example. So previous to Winco, it would be quite foolish to recommend that someone plead NCR unless the act was very serious, as people could be indefinitely in the system for acts that would have resulted in very little jail time, which is not justice, as many people committed acts without any criminal intent, but they couldn't plead NCR because the system was disproportionately punitive. So Winco meant that more lawyers recommended to clients that the forensic mental health system was an option when the situation fit it. And more people are getting out, but they are also still often held longer than their maximum sentence would have been. So it hasn't completely remedied the situation. As most people here probably know, most index offenses for people in the forensic system resulted in no or minor injury. Yet people who've committed no violent act can be detained when they don't do well in a highly structured environment. Okay, next slide. Right, oh, you've got there already, so you're so quick, Hannah. So I also talk a bit about rights within an institution, institutional policy. So I'm going to be talking about the Center for Addiction and Mental Health Bill of Patient Rights, which was created in partnership of CAMH and the Empowerment Council. Some of these rights have values rooted in the rulings that have come from the Supreme Court, and they're also rights, every one of which represents patient experience, and particularly the ones that are here are come from the experience of forensic patients. So the right to be treated with kindness and compassion, being allowed a range of feelings, the right to the least restrictive environment, least intrusive treatment, having an explanation for if you're unable to leave the unit and being told how you can acquire that ability, and the right to recovery-oriented trauma-informed care. So all of these have values that are quite similar to the rulings in Matsy and Pinett. I need to describe the Matsy case, and this is an issue that of being able to access therapy that was not being provided in the forensic system. It was an issue that was identified by people in the forensic system throughout Canada. When we did our first ever survey of people in the forensic system across the country to find out what they thought of the system and what their experience was of the system, one of the things that was very frequently identified was not getting the therapy that they needed, especially for having abuse histories, which made it really difficult to heal. And part of this unaddressed need is exacerbated by the danger of expressing feelings and having this be seen as if someone is therefore become a greater risk. And this is the conflict of the forensic system, when the people who are charged with healing are also the people who are charged with keeping a person in custody. So one solution that is what resulted from Matsy was that review boards have the power to order what the person is showing that they need in order to be able to heal, which doesn't necessarily occur within the forensic system itself. So other rights are about the right to have your health record include only relevant facts and not speculation or prejudice. An example would be a forensic patient talked about how one day there was just agency staff, nurses who didn't know them well, and they wrote that the person was aggressive, which they concluded just from the expression on their face. Well, apparently they have like a resting grouchy face, which the other staff knew. But when something like this gets into your record when you're a forensic patient, it can have a detrimental effect on what happens to you in the future. So it's a significant issue. Right to daily access to the outdoors in accordance with the law. This is a very difficult right to achieve, and yet I think what's not paid attention to is the detrimental effect of not having access to the outdoors and not having access to exercise and not often understanding how you can get it. Being restricted to a unit might seem like a small thing to many people who work in the system, but that's actually what jail is. It's a significant loss of liberty that can have a very negative effect on people's mental and emotional well-being. Rates within the institution can also result in arbitrary interpretations being made. For instance, in some cases, there being a lack of understanding of differences in cultural expression, such as being more emotional. There's about half of the people in the forensic system at this point have immigrated to Canada, and there's a higher percentage of people who are Black in the forensic system than in the general population. And I've certainly had people tell me that they feel that the more emotional expression that happens in their family isn't one that's welcome or understood when they're in the forensic system. The rate to get least owners and least restrictive care is very difficult to litigate because it takes a long time for things to work their way through the courts. So it's really very helpful if it can be recognized at the institutional level or and upheld by the review board if it's not recognized at the institutional level, so that there's some recognition that deprivation of liberty is a very serious thing to happen to people, even within the system itself. According to the law, capable people, even if they're in the forensic system, can't be forced to take treatments that they don't want. However, people get coerced into it by being told that they won't get released unless they take medication. Even if they have previously come, some cases from another facility where they're doing perfectly fine without medication, if they get a doctor who believes strongly that it's important to always take it, then they are in a very difficult position. And it's difficult for them to really exercise the right to refuse. Okay, next slide. So we don't always succeed. In the Bill of Patient Rights is a huge accomplishment, and we've won an award for it from the Ontario Patient Council, Ontario Association of Patient Councils, but it doesn't mean we always win our battles. And for example, there's a policy at the Centre for Addiction and Mental Health for something called SouthPod. It's where people can be placed in seclusion where they have not consented and they also don't meet the requirements for restraint, and yet can be kept there for long periods of time. Anita, did you want to say anything about your client's experience of SouthPod?
Yes, I can. Agreeing with all that's been said, Jennifer reminded me last night around midnight, and we're still chatting about this stuff, that some number of years ago, it was a long time ago now, maybe 10 or more years ago, I had a series of cases before the Ontario Review Board that looked at, who was in the SouthPod unit, for how long, why, was it, legitimate, the kinds of time they were spending there. And we did, the review board has to look at things case by case, so it can't do a systemic review. It's not, a board of inquiry. It's not a royal commission. It's not even an inquest that can look at more than one case at the same time. But it was my experience at that time that throughout about a 3.5-year window, there were 4 Black men who were segregated into the SouthPod. I never saw a white person put into this area at that time, in that period of almost 4 years. And one of the individuals who spent a very, very long time in the SouthPod, segregated there, was a young person. I guess if they were at CAM age, because they would have already turned 18, but just so someone who's very, very young. The review board considered his situation, how long he'd been there, and ordered CAMH to discharge him from SouthPod, and said it was no longer appropriate or reasonable for the individual to be there. But we came back several months later, and the individual was still there, and that's sort of the most exercised I've seen the review board in terms of their direction to a facility not being followed. And they used, from what I recall, extremely strong language along the lines of egregious conduct. So that the use of South Pod was considered several times during that period, and there were real concerns flagged about how long people were being segregated in this particular area. So I haven't personally had cases come up with South Pod recently, but there was a period of time where the review board was reviewing a lot of these cases, and I'm actually not sure why they're not coming before the review board anymore. It's possible they're not being reported as seclusion as they should be. So I'm not sure why we're not seeing it, but it's definitely acknowledged as a very problematic use effectively of seclusion.
I understand it's very rarely used anymore. So hopefully that's why, but it still is there as an option. Other times legal review processes can make a positive difference. So thinking of the Jeffrey James inquest where someone died in restraints at CAMH, and they adopted and rigorously followed all the agreements that they made at the inquest to ameliorate restraint use at CAMH. And actually this became an Ontario-wide initiative because the Registered Nurses Association also took on the topic of mechanical restraint use and its use. We still need more work. There's been very little attention to chemical restraint use. It takes a while to change institutional culture. And there is a great education program called Trauma-Informed De-escalation at CAMH, but not everyone takes as readily to it, but some people progress through such educational initiatives, others resist. Such is the nature of large institutions. Next slide. So non-legal peer advocacy institutions is really important. So because there is an independent advocacy voice for patients, we can not only just respond to things that happen, we can sort of get ahead of things and ask the institution if they will explore issues to see whether people are being treated justly. So one of our advocacy issues was to ask CAMH to start keeping demographic analyses on the use of force, so the use of restraints at CAMH. And when doing so, it emerged that Black patients were being restrained at approximately 3 times the rate of patients who are white. And this was particularly problematic in forensics. So as a result, CAMH responded with a anti-Black racism initiative that's extended to pretty much every aspect of care, and that the staff are all expected to attend. So it's good that this came to light at CAMH. However, there's no reason to think that it's restricted to this facility. In fact, I'm positive that it's not. And so it actually needs to be required to be done at every facility. Next slide. So Empowerment Council is the only peer advocacy organization for people with lived experience in the country that regularly intervenes in cases before the Supreme Court. As Anita mentioned, we've been citing in rulings that have changed national case law, and we've also been referred to in federal legislation in support of changes to the law. So because legal advocacy isn't just through the courts, we can also do it by lobbying for legislative change. We've talked to provincial and federal and Senate committees, and we're cited in Hansard when the national legislature made changes to the criminal code that allowed people who were found unfit to stand trial to have their charges stayed if the charges were fairly minor, but they were being held just because they're never going to be able to understand the legal process. We did not succeed in preventing victim impact statements, however. So next slide. Oh, yes, you're so quick, Hannah. Legal goals going forward. Some examples would be a case we have that's pending. British Columbia is a province in which anytime someone's involuntarily admitted, they're automatically assumed to be incapable of consenting to treatment, which flies in the face of all the evidence about people's capacity to consent to treatment, the vast majority of people in the mental health system. So we're one of the parties that's intervening in that case. I would like to see us challenge the constitutionality of victim impact statements. To my mind, it's akin to somebody who's having a heart attack and accidentally ran somebody over while they were having it, having to hear about the impact of that every year, even though the reason that they're currently being controlled is to identify their current mental state, not the mental state or their act that they committed years before in a different mental state. And also, victim impact statements, whether in judicial or forensic system, also tend to, I think they favor certain types of victims. I think it creates unequal justice. I think that victims do need a place to address their needs, but I don't think it should be in deciding the sentences for accused. And the similar thing should also happen with people who are designated high risk. It's not a risk that's actually based in science. As a matter of fact, murder, for example, has a very low recidivism rate, which is counterintuitive, and yet true. Okay, next slide. So as I mentioned, one of our goals, so a non-legal goal, is to have made public demographic data on race, indigeneity, gender identity, religion, etc., in relation to the use of restraints, detention length, rates of discharge, security level for NCRQs. Also, as an issue that was identified by forensic patients throughout the country, there needs to be more attention to NCR who have a history of trauma, and which is seldom addressed in the forensic system, with a focus instead on medication and cognitive behavioral therapy. And this isn't just actually the forensic system. People in the civil system say much the same thing. More trauma-based therapy. Thank you. Okay, I'm going to end. It means changing the culture often of the mental health system, in which there are many kindly people within it and many attempts to be kindly, but there also needs to be constant vigilance to its erosion of the dignity that human rights work to maintain. Now, questions or comments?
Thank you so much, Anita and Jennifer, for such a thorough presentation. And my colleague Taryn.
I can't hear you very well, Erin. I don't know if other people can.
Is that better?
You're a bit quiet. Yeah.
You're very quiet, yes.
I can't hear you either.
Maybe yell.
Okay, I'll speak up a little bit and let me know if it's not improved. Thanks so much. Great, perfect, thank you. Thank you so much, Jennifer and Anita, for such a thorough presentation and such a thorough overview of sort of the history here and the goals going forward. So anyone who would like to ask a question, as Taryn has mentioned, you can use the chat feature to submit those questions. And we'll be taking questions for the next few minutes. Maybe to get us started, one of the themes that was discussed throughout your presentation is the right to consent to treatment. And I was wondering if you could speak a little bit about Anita, you mentioned the side effects that can come with certain medications, and just speaking as someone who was not working in the legal system and was not on the health side of things, that was a steep learning curve for me when I learned because I think a lot of people in the public who don't know this issue very well think, well, if someone is unwell, shouldn't they be treated? And they don't necessarily know what that all entails. So I was wondering if you could speak very briefly on that, and then we'll go to Colleen's question.
One thing people often don't recognize is that some of the side effects can actually increase what then is considered risk. So say somebody can't stop pacing. They're pacing back and forth. They seem really agitated. Well, that's akathisia. It's a side effect of psychiatric medication, which ironically can then make them seem to people who don't understand more dangerous and then end up getting even more medicated. Also, it can cause lasting cognitive difficulties like tardive dyskinesia, which can result in people having tics and trembles and involuntary mouth movements. Isn't necessarily reversible. So people can get a permanent sort of disfiguring, or at least people feel as if it's disfiguring, result from medications that might be permanent.
And I too, not being a physician, not having any knowledge of these medications, it took me a long time to figure things out. Early on in my career was the time in history when the sort of traditional antipsychotics like Haldol and these neuroleptics were sort of being switched over into the second generation oral medications, risperidone, olanzapine, clozapine, that were being heralded at the time by psychiatry as not having any side effects. And so I was very naive about, this is the, brave new world. We don't have to worry about, extrapyramidal side effects and Parkinsonian and movement disorders and tardive dyskinesia anymore. This is going to be great. And I remember the late, great Don Weitz at the time saying to me, hang on a minute, it took 25 or 30 years for the last set to show us what it really does long term. And sure enough, he and the other psychiatric consumers and survivors were right, because here we are with the second generation oral medications, gravely increasing the risk of metabolic syndrome and diabetes and high lipids, high fats, cardiovascular disease, and causing young people, including men in their 20s, mostly Black men that I see, having these very serious chronic illnesses that then shave 10 or 15 years off the average life expectancy. So maybe they don't have Parkinsonian tardive dyskinesia movements, but they die well before they should from heart disease and diabetes. That's not particularly well managed by a lot of our clients. So, it's a big disaster. And it's also a self-fulfilling prophecy in that if you have someone with serious mental health issues who doesn't look after their diabetes or heart disease that the medications gave them, they end up certified, as posing a risk of harm to themselves because they're not managing these difficult chronic illnesses, which we gave them by forcing these drugs on them, by declaring them incapable. And I find a lot of this is a huge injustice to an entire population of people who maybe if we just left them alone, wouldn't be having to deal with any of these, severe interventions. And the psychiatry's own role in it is not sort of transparently recognized. They're just presented as these people who lack insight and are not looking after their medical conditions as if these medical conditions would have naturally occurred without the interventions in the first place. And I don't think that's fair. And there's also, I think, the differential impact on race. And I think that's something that really needs to be examined. Sorry, long answer. Sorry.
Thank you. Yeah, that was helpful, Anita. and just to clarify, my question was not to suggest that medication should not be available, more so just that a lot of people don't necessarily know what that entails, and so you sort of hear, well, why so the layperson might think, why not treat someone if they're sick, and so there's obviously that other level of symptoms to consider. But I've talked enough. Colleen, please.
Hello, my name is Colleen Allen. I'm actually a board member of PeerWorks, formerly the Ontario Peer Development Initiative. And so attending this particular workshop has been extremely interesting for me because it's opened my eyes to a bunch of things that I probably should have thought about, given I have a diploma in law from Fanshawe College as well and worked as a law clerk. And so I found it very interesting how you presented all of these pieces. And I'm finding that this is opening my mind to the idea that even though we're here to promote peer support and to help continue the existence of the 9 remaining independent CSIs in Ontario, that there are pieces that we can branch out into and look further at from what you present. So that was the first thing I wanted to say. The second thing I wanted to say, by the way, is that as you were presenting these pieces with dealing with the forensic system, the first thought in my head is, if I go back 30 years ago, what you're talking about happening now within the forensic system was happening in the general public back then, right? With the CSI movement and the closing of many institutions. And so now I'm sitting here thinking, great, we're just fighting the same battleground again, only now we're fighting it within a rather closed system as opposed to fighting it, in a bigger system originally. And I hope I'm not wrong in the way I've expressed that. I hope I'm making sense when I say that. It's kind of like watching 30 years ago be repeated again, only this time in a smaller box, if that makes sense.
I think the forensic system is growing disproportionately because of the lack of adequate services, community services, enough peer services being resourced. I mean, Ontario used to be a world leader in its provision of peer services, and now are lagging sadly far behind. So yes, I strongly believe that if community level services and peer services were better resourced, that we'd have far fewer use of the institutional sector, and the most institutionalizing of all being the forensic sector, the mental health system.
We maybe have time for one last question if there's anyone who wants to put their hand up. And I'll check and scroll through to make sure we're not missing anyone. Going once. Okay.
I think Sherry will be very happy if you take this time to fill out your evaluation form.
Yeah, thanks for reminding us, Jennifer. Thank you so much, everyone who's participated, and thank you again so very, very much to Jennifer Chambers, Anita Szigeti, and of course Hannah Wilson for all of her support on the back end.
Yes.
Our conference organizers are very interested, and as are we, of course, at the PHSJCC, are very interested in your feedback on presentations today. So if you would be it would be wonderful and very much appreciated if you could complete the survey on this presentation, and that survey is found on the session page that you would have connected to the Zoom meeting for. It takes approximately 2 minutes to fill out, and we are right at time. Thank you so much, everyone, for joining, and thanks again to our presenters.
Thank you
Thank you all
much
for being here.
us. Thank you. Thanks to Jen and Hannah and Erin and Taryn and everybody. Thank you so much. Bye-bye.
Great seeing you both.
Bye.
Bye-bye.